Welcome everybody. Happy New Year to everybody. This is our first webinar back of 2026. I see there's a lot of people joining at the moment. So while everybody is joining and getting comfortable, I'm just going to introduce the webinar today. So today we're going to be talking about the appeals process. So when a care order has been granted, is there an appeals process and what that looks like, and is it different for the various different care orders? We have done a number of webinars discussing the different care orders, ranging from supervision orders, interim care orders, full care orders, and all of those webinars recordings can be found on both our website, which we'll put the links in the chat, and the Legal Aid Board website as well. And they're on our YouTube channel. So please feel free to share them or revisit them. And any questions or anything, please use the chat functions today. If there's anything you want to ask in relation to today's topic or future topics or previous topics, please put in any questions and we'll try our best to answer them. And the webinars are recorded, so we will be recording this webinar as well. For those of you who don't know me, my name is Niamh McCarthy and I manage the parental advocacy service for Bernardo's, which supports parents of children in care. We offer face-to-face support in Dublin North City, Waterford and Wexford. And we also have an information and advice service, which we'll share all the details with at the end as well. And that's a national service. I'm joined today by the Managing Solicitor of through the Legal Aid Board in Chancery, Stephen Cahill, and he's very generous with his time. So I'll be putting all of our questions to Stephen today. But please feel free again to use the chat. You're very welcome, Stephen.
Thanks very much, Niamh.
Great. So as I was just saying there in the introduction, like we've had a lot of discussions around the various care orders and what happens. And I suppose in your experience as well, so if I'm a parent and I have an interim care order has just been granted and I'm wondering, and I don't agree with the outcome, the order, can I appeal it there and then? Or should I go to my solicitor, have a consult, discuss the merits of appeal, or what's the best advice in those situations?
Sure. If you were legally represented at that application when an order was made, one of the first things a solicitor will talk to you after you finish court is, the outcome, the nature and effect of the order that's just been made, and then what are your options? And one of your options is, of course, to appeal that order. So a person has the right to appeal any decision of the district court to the circuit court. So the solicitor will advise you, that you have that option, and then hopefully will start to guide you through that process.
Great. And is it a long process, Stephen? Because I know obviously if an interim care order, I'm just thinking about interim care orders at the minute. If an interim care order has been granted for 28 days, would the appeal be heard before the interim care order, the next time we were due back in court for the next interim care order hearing, or would they be heard together?
So your appeal is from the district court to the circuit court. So your appeal is to a different court. You are then, of course, somewhat at the mercy of the court lists in the circuit court. But you can always make representations to the circuit court to try get as quick a hearing as possible. But you should also note that if a court makes an order in the district court, at the time of the making of an order, you can apply for what's called a stay upon an order pending an appeal. So you can ask the court to basically pause its order until you've had the opportunity to have an appeal heard in the circuit court. Now, it's quite rare that a district court judge would grant a stay on their order. Like if they've determined the safety of a child requires it, they're probably unlikely to grant it. But there are certain circumstances where a stay might be granted. So it's always worthwhile applying for a stay if you intend to appeal.
Okay, that's really interesting. Yeah, because my next question was going to be if that was common practice. But one of the scenarios that has come up for a number of our parents when they're talking, when they've been asking about appeals is, and you mentioned it there, if you were represented, where
Mhm.
in cases where they have just got notice that there's an interim care order being sought, they haven't had representation, they go to court without representation, the hearing still goes ahead, and the order is granted. Um, and I know in the past you have always said the first thing you should do is always contact the law centre and it will be prioritised. But in some cases, people have turned up in court without representation.
Yeah.
How do they find out what to do then?
So you can apply, even if you weren't represented in the initial set of proceedings, you can apply for legal aid and advice in respect of your options now that it's happened. So you can immediately apply again to your local law centre, let them know that it's a childcare matter and it'll be treated as a priority. So that solicitor then will hopefully meet with you, if not straight away, very, very soon thereafter, and can talk to you about an appeals process, whether they would advise, for it or perhaps against it, or maybe if they'll think that an alternative is better suited. So my position usually remains the same, that it's always in your best interest to get early legal advice to guide you through what is a complex legal area.
Yeah, yeah. And is the appeals process long, Stephen, or is it once it's obviously it goes to the circuit court, it's put on the schedule at some point, a hearing is scheduled, and then is it over a number of days? Is it one hearing, or how does it work then?
So there are a number of timelines involved. The first timeline that you're up against is the time upon which or within which you have to actually appeal.
Okay.
So if the district court makes an order or refuses an order, you only have 14 days to file your notice of intention to appeal. So that's your first step. If you are going to appeal, is you must complete and file in the court office your notice of intention to appeal. And that must be done within 14 days. So that's your first step. Once that notice of appeal is filed, your next step then is to serve it on all the other parties. So you have to notify the other parties involved of your intention to appeal. So that has to be done. Once that is done, the circuit court office then will receive the papers and they'll write out to the parties with the time of the hearing that's being allocated. It may be that if, for example, you're appealing an emergency care order, which only lasts for a period of a week,
Mm.
you have a very short period of time really for an appeal to be effective. Because if your appeal gets on when it's expired, your appeal is moot. So as an access to justice issue, you need to get your appeal on before that order expires. So you can make representations to the court office and say, this is a real, very urgent matter, and you can make applications to the circuit court if necessary to seek an early hearing date. But in general, you file your notice, you serve it, and then the circuit court will give you your hearing date.
Okay, that's really interesting. And is so, for example, for what a scenario that comes up a lot for us as well, for parents, is if there's a full care order hearing and the parent is maybe a parental capacity assessment has taken place and there's various recommendations and our parents are engaged in that process, that they may be doing therapeutic supports, they may be, working through the level of supports, maybe coming out of active addiction, but are making positive steps, but aren't quite there at the time of the full care order hearing. And the, I suppose, when it comes to appeals in those cases, 14 days is such a short time to allow a parent to showcase the positive steps or they have the intention of making positive change. So, is there an option further down the line for a parent to come back in?
Yeah, so you've made a very good point there that, if a parent is taking steps, if you allow further time to elapse, the parent may be in a stronger position. And that's why there is often merit and grounds to appealing orders of the district court, so making an initial interim care order or indeed a care order. Because while you have to file your notice within 14 days, you may actually not get a hearing for a number of months. So
Okay.
by the time that hearing comes on, you are in a stronger position. And a really important feature of an appeal from the district court is that it's what's called a de novo hearing. So it's a completely fresh hearing. So the Child and Family Agency have to completely reprove their case. And you take it as at the time of that hearing. And you, as the parent, may be in a much stronger position then. So it may be more difficult for the agency to prove their case to the required standard at that point. So that's certainly one of the reasons that feed into an appeal being worthwhile.
Okay. And if you've decided you are going to follow the appeals process, do you have to apply for a new legal aid cert or is it still covered on your existing cert?
Yeah, so you wouldn't be automatically represented for the appeal. As part of your district court representation with the legal aid board, they would assist you with filing the papers and serving the papers for an appeal, but they're not, I suppose, on record or on board automatically for the appeal itself. The legal aid board would need to consider a few matters in deciding whether or not it's appropriate to grant legal aid for an appeal because it's not
Okay.
all automatic.
Okay. And what kind of considerations would they look at, Stephen, in those cases?
Sure. So one of the matters they would look at is there any prospect of success? So
Okay.
it may be that there's zero likelihood, zero prospect of success effectively. That doesn't automatically mean you won't be given legal aid, but it's a factor that is considered. The legal aid board, the solicitor would reflect on what occurred in the district court. In effect, were you given a full and fair hearing? Were there any defects in that hearing? Are there any other remedies? Or are you better off pursuing an alternative to an appeal, which, as you referred to earlier, might be engaging with therapeutics and so on for a further period? And that may be more advisable than trying to pursue an appeal that won't ultimately be successful.
Yeah. And do all appeals take place in person as well, the same as the district court runs, or are there online hearings?
So the hearings are all in person. It's run the exact same way as a hearing in the district court would be. There can be provision if a party is unavailable to attend, then they can be facilitated with video link or whatnot. But yes, it's an in-person hearing run exactly the same as it was in the district court.
And if you're still unhappy with the outcome of the circuit court, can you appeal that decision?
Unfortunately not. So the circuit court will be the last court to which you can appeal to. But if the court made an error in law, for example, you might have a different remedy, which is what is called a judicial review.
Okay.
So that's an application that you make to the High Court, where you would look to have that decision effectively quashed or set aside on the basis that a judge made an error in law or misapplied the law or something similar to that. But otherwise, there's no further remedy beyond that appeal to the circuit court.
Okay, yeah, because we often hear people talking about judicial reviews and we're going to take a judicial review and pieces like that. So is there a criteria you need to meet for there to be enough, I suppose, evidence for a judicial review or an application for a judicial review?
You would want to have a strong basis and a strong grounds upon which um, you'd need to have there before considering instituting an application to the High Court for judicial review. Um, it's it entirely depends on the circumstances and what you assert the problem was with the hearing. And that's, again, a matter you really need to take legal advices upon, because, again, you also have timelines at play before you can bring a judicial review, or sorry, within which you can bring a judicial review. So if you don't bring your judicial review within 3 months, you're out of time. So you have to act quickly as well in that regard.
They're all very tight timeframes, aren't they?
They are, yeah.
Yeah. The other thing that comes up quite often is, so we have our care order hearings, but I suppose while those hearings are going on, there may be Section 47 hearings happening, maybe around change of school, for example, or there may be access orders being heard as well. And I suppose can they be reviewed, the decisions around, say, a Section 47, can that be appealed separately to an order, for example?
Yeah. So the starting principle is that you can appeal any decision of the district court to the circuit court. So if a court, for example, extends an interim care order and at the same time grants an order permitting a child to change school, for example, and the parent's not happy with that, you can appeal just that order to the circuit court. So you don't have to appeal the whole set of proceedings. You can appeal just the individual decision with which you're dissatisfied.
Okay, very good. And is it a solicitor then that will represent you in the circuit court, or does it get escalated up to a barrister?
So your starting point will be that you'll be represented by a solicitor in the circuit court. If it's a legal aid board solicitor, that solicitor may elect to seek to instruct a junior counsel if the circumstances are complex enough, or if the case itself warrants it. But ordinarily, you will be represented by a solicitor in the circuit court.
Quite a complex one, this one, and I'm not sure if we'll have the answer, but if there's criminal proceedings going on at the same time as childcare hearings, and those criminal proceedings have maybe used as evidence, for example, within the childcare case, we'll just take the example of maybe physical abuse of a child, and so cruelty of a child, and thinking about if the parent is appealing the criminal case, does that have an impact on the childcare cases as well, or is there crossover among those?
So while the subject matter, I suppose, might be in common between a childcare case that TUSLA have issued in the district court and maybe a criminal prosecution in the criminal courts, they are separate and distinct. But there are going to be obvious certain crossovers. A matter that the guards believe warrants a prosecution are likely to be the same thing that means TUSLA believe a child needs to be perhaps removed from the care of a parent. It's very difficult you can't exclude criminal matters from the childcare case and vice versa. It is the same subject matter in general.
Yeah. And if somebody was successful in appealing their conviction, for example, on a criminal case, could that have an impact then on their childcare case?
Yes. I mean, if you have a conviction for a certain matter, say, for example, assault versus a child, that is a matter of fact that has been found to have occurred if you have the conviction in the criminal courts. So that can be relied upon then by a judge hearing your childcare case. If that conviction has been overturned, or if you're found not guilty, that doesn't mean that you've been in effect exonerated. It just means that allegation wasn't proven to the requisite standard in the criminal courts, which is beyond a reasonable doubt. Whereas in the childcare courts, it's a different burden of proof. It's just on the balance of probabilities. So it's not beyond reasonable doubt. It's a lower bar in the childcare case for them to prove something.
Okay, really interesting. Just a question in relation to something we talked about a few minutes ago. When the legal aid board was assessing the viability, I suppose, of taking an appeals forward, and they've gone through their criteria, and for whatever reason, they said, no, we don't believe this appeal is viable, but the parent may want to still continue with it. They can still lodge an appeal, is that correct? But they just won't be represented by
Yeah,
the legal aid board.
yeah, absolutely. So, firstly, any party is entitled to represent themselves and can pursue an appeal by themselves as a lay litigant. That's your absolute right to do that. But I would also say that even if you are refused legal aid initially, you'll be issued a letter setting out the basis, setting out why you weren't
Yeah.
granted aid. But it will also set out that you have grounds to appeal that decision. You could look to have that refusal reviewed or appealed as well to a committee who'll reconsider it. So an initial refusal isn't the end of the road either in terms of obtaining
Okay.
legal representation.
Very good. And if I was a parent who had a number of maybe accessibility difficulties, such as literacy, maybe was difficult for me, or English may not be my first language, or things like that, is there accommodations through the appeals process? Like, would your solicitor be able to lodge it for you, or is that the normal process?
Yeah, so your solicitor should assist you with filing your appeal in the first instance. It's relatively straightforward process. So there's a single form. You just fill out effectively the names of the parties and what order it is you're looking to challenge and what date it was made, and that's filed with the court office. So your solicitor can and should assist you with that. But even if you don't have a solicitor to assist you, the court office are actually very, very helpful and accommodating as well.
Great. And I'm just thinking for people with who may be accessing homeless accommodation or don't have a secure home at the moment, and maybe moving around quite a lot. With all their correspondence, could it be redirected to their solicitor, or what's the best advice to people in those circumstances?
Yeah, so that's entirely up to the individual. So the Child and Family Agency, if they're bringing an application, they have to serve the respondent. So usually the parents. So usually that's done directly. So the parents' efforts are made to serve the parents directly. That can be difficult, you're right, if a person doesn't have a stable or secure address for correspondence. So that person may allow their solicitor to accept service on their behalf. So sometimes that is done instead of the parent being served directly.
Yeah, yeah, because I'm even thinking about, even if a parent lodged an appeals process, like you said, it might be months down the line when they actually get their notice of hearing, but a lot of could have changed within those months as well. Like, um, and sometimes with a lot of chaotic situations, it's hard if you've no stable home as well to receive correspondence too.
Yeah,
Is there
absolutely.
is there anything about the appeals process, Stephen, that you'd really like to hone in on to tell parents or give them like the top tip or
One thing I would always try and impress upon a parent who has just had, say, a full care order made, that I'd always want to say to them that that is not the end of the road, that even if they ultimately decide that they're not in a position to appeal at present, that it's always open to a parent to come back to discharge a care order.
okay.
So that's separate to an appeal. That's actually where you would return to the district court, perhaps when your circumstances have improved. Maybe you've completed treatment, you've gone through aftercare and achieved and maintained sobriety in the community. And at that point, you may say, right, now I am in a position to resume care. You can apply to the district court to discharge, look to get rid of a care order that was previously made.
Okay. And if a parent was in those circumstances, they could obviously apply for legal aid to be represented in that those cases as well, could they?
Yeah, absolutely.
Okay, great. Um, I suppose one of the difficulties we would see there as well is in terms of there might have been many years where the parent was kind of looking after themselves or helping themselves to become better, maybe going through treatment, that the children may be very settled at that point, so in where they are, so discharging the order may not be in the best interest of the child, but threshold may not be met anymore. But is there other alternatives in those situations?
Well, I think there's definitely a balancing of rights in that kind of circumstance where a parent is perhaps ready to resume parenting, but the child has become so settled. So then the parent needs to, I suppose, decide whether or not they still wish to pursue looking to discharge it, or instead, if they're looking maybe to simply increase their contact, their access to have overnights, extended visits, things like that, instead of actually looking to discharge the care order. So that's another thing I'd always try and, again, make sure a parent is aware of, that even if a long-term care order is made, the door to the district court is always open. You can bring an access application at any stage on, 2 days notice. Well, so 7 days, I think. But at any stage, you can bring your access application. Um, so you don't need to, wait until it's almost gone too far.
Okay. Thanks very much, Stephen. I think we've learned a lot today. Definitely, I'm just going to double check there's no more questions in the chat or the Q&A. Um, no, there doesn't seem to be. So thank you so much for your time today. And like I said at the beginning, all of our recordings are available on our YouTube channel and the Legal Aid Board. And we're going to share those QR codes as well now on a slide, but we also have a feedback form, so please feel free to fill in the form, give us as much feedback for future topics or questions you may want to ask or anything like that. Please, it's all very welcome. We're not precious about this stuff. So and look forward to seeing everybody next week. Thank you so much. Thanks everybody, and thanks Stephen.
Thanks very much, Steve.
Going to give people a minute there to just fill in the form. I think there's still a few people logged on, and we'll close the meeting at 1:30 exactly. Thank you all so much for attending.